You are Namus Perez Cajax?
Yes.
Sir, you are charged with failure to stop and give information, leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and or a $2,000 fine.
Quick pause here. This is important. Probable cause hearings are not trials. The judge isn't deciding guilt yet, only whether there's enough evidence to keep the case moving forward. But make no mistake, what's said right now can still come back to haunt the defendant later. Would you be comfortable answering questions this early without a lawyer?
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officers were dispatched to a minor crash. Upon arrival, officers observed damaged vehicle that was no longer drivable. Complaining witness advised that a black vehicle disregarded a stop sign. Complaining witness advised the vehicle stopped briefly before driving away. A witness saw the crash and took a picture of the license plate. Officers ran the plate and found the defendant was the registered owner. Officers made contact with the defendant, and defendant agreed to meet officers at scene of crash. Defendant admitted to being involved in the accident. He advised that he is the owner and the only driver of the vehicle.
And just like that, probable cause is found. That single sentence means the case survives its first legal test. From here on out, the stakes jump significantly. Jail time, fines, and long-term consequences are officially on the table. This is where things stop being theoretical and start getting very real.
The defendant advised the officers that he did not see a lot of damage and saw that the complaining witness was uninjured, so he left. Estimate of damage is $1,000.
Mr. Perez, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen?
No.
Are you in this country with or without permission?
Without permission.
What happens if you go to jail, Mr. Perez?
I don't know.
Are you in this country with or without permission?
Está en el país con o sin permiso. Without permission.
I want you to think,
Quiero que piense.
what happens if you go to jail?
This is one of the most sobering moments in the hearing. The judge isn't just warning him. This is a blunt explanation of how the criminal and immigration systems can collide. A simple violation could trigger months or years of detention. Do you think judges should explain immigration consequences this directly, or does this cross a line?
Bueno, si voy a la cárcel, pues voy a cumplir con lo que diga el juez.
Well, if I go to jail, I'll comply with what judge says.
You're not in this country with permission.
Está en el país.
Immigration sweeps the jail on a daily basis, every 6 to 8 hours. If you go to jail and immigration finds you there, they will put a detainer on you and you will sit in jail until first this case is over with, and then you will be shipped off to immigration, or you will sit for another 6 to 9 months waiting for them to do whatever they're going to do.
Notice the zero tolerance tone here. No emergencies, no excuses, no sympathy. When a judge makes conditions this clear, violating them isn't just a mistake. It's seen as outright defiance. This is the kind of warning defense attorneys beg their clients to take seriously.
If you don't want that to happen, then do not violate the conditions I put on you now. Number 1, do not pick up a new case. Number 2, you do not have a Texas driver license, so you are not allowed to drive. I am having you sign a promise with me today. This is an affidavit that you're not going to drive, and I don't care what is going on in your life. I don't care if you need groceries. I don't care if someone has to go to the hospital. I don't care if Bambi gets run over and needs to go to the hospital. You get into a car and drive. You can be doing a substantial amount of time in jail. Do you understand? This is an affidavit you're signing, promising me that you're not going to drive. I'll have you first sign this. After that, I'm going to get you to Victoria. We will have you sign a reset. We're going to get you out of here. You need a lawyer. So we are going to give you time to go hire a lawyer. I'll have you sign the reset, and after that, you'll be free to go. When you come back, please have a lawyer. Do not pick up any more criminal cases. Do you understand? Okay?
Thank you.
I can't tell you how upsetting it is, the way that you've treated us. It's absolutely just Your case is 1,580, it's nearly 1,600 days old, and you want them to just, oh, and you come in shorts? Really? Did you go to church looking like this?
Okay.
So why come to court like this?
I wasn't aware of it. This was my first time, actually.
This is a courtroom. Don't play this, I didn't know. It is a courtroom. You should know how to address in a courtroom, considering that your case is nearly 1,600 days old. How many years is that, Mr. Napoleon?
This courtroom shift is wild. We go from legal procedure to a full-blown lecture on respect. Courtroom decorum matters more than people realize. It signals accountability. Showing up unprepared or dressed casually can instantly destroy whatever goodwill you might have had. Do you think appearance should matter this much in court?
4 years.
You have until next Monday to get the mitigation packet done. If you don't have it done, then you will get an immediate 10-day trial setting. And I don't care who's got what. State, get ready for trial now, please. Get everything that you need to get now, because I'm fast tracking this to trial. And I don't care what came this, what came that. Jesus came down to prevent you from doing, I don't care. You have until Monday to get the mitigation packet done. And if you don't have it, then you will either accept the plea bargain from the state or you will get a 10-day trial setting.
Yes, sir.
Do you understand? And if you come back again in shorts, I can't tell you the level of disrespect that shows, not to mention the fact that your case is 4 years old. I mean, it's a double kick in the ding-ding to us, really. And you ought to be ashamed, because that's not the way someone acts. All right, take a seat for me. We'll be back. Good morning, Mr. Hodges. Could you run an NCIC on him, please? What all does he have open elsewhere?
Yes, Judge, I'll run it right now.
And then if you can refresh my memory with regard to our case as well, please.
Yes, sir. In regard to open cases, it appears in Galveston, he has an open UCW, DWI, and a collision involving damage to a vehicle equal to $200.
It says an FSGI, DWI, and a UCW.
Yes, Judge. And then in regard to this case, the officer responded to a criminal mischief and made contact with the complainant, where the complainant stated he woke up and realized his tree had been ran into. He checked the surveillance and observed the defendant's motor vehicle colliding into the tree, traveling at a high rate of speed, and observed the defendant appearing to get out of the motor vehicle, walk in front of the vehicle, then get back in. And the officer later observed tire marks damaged on the landscape leading up to the tree, damage to the bricks around the tree, as well as damage to the tree itself, leading to a damage of approximately $200 for the grass and bricks.
This is the judge laying bare the philosophy behind bond restrictions. Driving isn't a right, it's a privilege, and one the court is clearly not convinced this defendant respects yet. The message is simple: show real change, not apologies. Actions over words. Would you trust this person back on the road?